Okay, this is kind of a double video, so there's another one, but this one should be shorter. So this is about justification for non-performance, which is mistake and changed circumstances. We're gonna do modifications in a different video. So first, it keeps going to duress, undue influence, that's process-based. So misrepresentation and mistake are substantive. Defenses against enforcement, mistake, impracticability, frustration of purpose. So this is like, why shouldn't we enforce the contract? Well, there was a mistake. It's impracticable. There was a frustration of purpose. These are questions of law for a judge. And what's a mistake? 151 says a mistake is a belief that is not in accord with facts, changes that have occurred since the contract was made or have been brought to light. So there's two types. There's mutual mistake, and then there's unilateral mistake. So mutual mistake is made by both parties, and basically it's a problem of mutual assent. So 152 says when a mistake of both parties makes a contract voidable. So there's three elements. Mistakes concern a basic assumption on which a contract was made. Mistake was fundamental to, so what could be a basic assumption? And those could be, the mistake was fundamental to the consideration, what was induced. It doesn't mean value, but this hypo is the barren cow. The cow was not valued wrong. The cow's actual state was wrong. It was not barren, so it's like a completely different product. And then I need to stop saying I don't do that in person, so I don't know why I'm doing it on these videos. The second, so it could be a mistake on the basic assumption in which the assent was made, or it could be a mistake has a material effect on the agreed upon exchange. When determining material effect, relief sought is considered in the analysis. So the party seeking avoidance must not bear the risk of the mistake. So they cannot have signed a contract that says, 154 says when a party bears the risk of a mistake, a party bears the risk of a mistake when, and this is called the superior risk bearer. And there's three, it could bear the risk when the risk is allocated to him by agreement of the parties. Contracts explicitly says, or caveat emptor. 2, he is aware at the time the contract is made that he only has limited knowledge with respect to the facts to which the mistake relates, but he treats the limited knowledge as sufficient. So like, inspect it as much as you want and you take it as is. So he says, oh, I'm inspected it as I want. And 3, the risk is allocated to him by the court on the ground that it is reasonable in the circumstances to do so. And then, so that's mutual mistake. We both made a mistake, and now I don't want to enforce the contract because we were both wrong. Unilateral mistake is only made by one party, though, and so that is generally relief will not be granted if only one party of the contract made the mistake. There's always a but. 153 says when a mistake of one party makes a contract voidable is where a mistake of one party at the time of contract was made as to basic assumption on which he made the contract, so kind of like the last one. 2, has a material effect on the agreed exchange of performances that is adverse to him. The contract is voidable to him. And if he does not bear the risk of the mistake under the rule 154. So this was the sump pump case that he met 1 and 2, but 3, he bore the risk. It said, I've examined the property and I take it as is. And so, and D, the effect of the mistake is such that enforcement of the contract would be unconscionable, or the other party had reason to know of the mistake or his faults caused the mistake. So if you had reason to know or your fault, you're going to be on the hook. So here there's a Wilford 4-part test, and it says mistake relates to a material feature of the contract. Mistake occurs notwithstanding the exercise of reasonable care. Mistake is of such grave consequence that enforcement of the contract would be unconscionable. Party can be placed in status quo. So they're trying not to screw anyone over. And so for the final, you want to go through both tests. So then the mistake can be a mistake of law. Many courts exclude regarding law. because error of the law is no excuse. But the modern view is more open to including mistake of law. And 151 says, facts are included in the law, comment B. They say they treat the law in existence at the time of the making of the contract as part of the total state of facts at the time. A party's erroneous belief with respect to the law is found in statute, regulation, judicial decision, or elsewhere, or with respect to the legal consequence of the act may come within these rules. But even so, you are probably on notice of the mistake from the law, which makes the party culpable. So, probably not going to go there. Remedy, rule of rescission. A contract may be rescinded because of mutual misapprehension. But I don't think that's what I meant. Because of mutual misapprehension of the parties, but this remedy is only granted at the sound discretion of the court. So I think it's misrepresentation. The court will try to return each party to the position they were in before the contract, so they may reform the contract or they may do restitution. So a benefit conferred. This may include returning money or land. The court may try to rectify the situation. If you had 100 acres, was the agreed upon land, but there's only 90, court may reduce the price by 10% to not implode the whole deal. So that is mistake. And then you also have changed circumstances. So this is impossibility, impracticability, and frustration of purpose. And so that's, so the world in which we created this contract is different. That's basically what the changed circumstances will be. And so impossibility is no one can do it, and this is historically strict liability. Today, a court may give damages, and the reason for this could be destruction when a person or thing necessary for performance of the agreement dies or is incapacitated or is destroyed or damaged. The duty of performance is excused. This is ordinarily easier to apply to unique goods. This could also be prohibition of performance by government action. That makes it impossible. Impracticability, I cannot do it, which is subjective. Clearly not impossible, but significantly different from what the parties both contemplated at the time of contracting. So this is use of gravel from one location, but not enough to an excavation from underwater made it impossible cost-wise for excavation. And the court said, yeah, we're not going to make you bankrupt yourself. Typically, a fixed price contract is meant to cover most events like market fluctuations, but there might be big deals that would make it impracticable. Restatement 261, discharge by supervening impracticability, where after a contract is made, a party's performance is made impracticable without his fault by occurrence of an event, the non-occurrence of which was a basic assumption of which the contract was made. His duty to render the performance is discharged unless the language or circumstances indicate the contrary. So obviously you can always contract around anything, but these are kind of defenses to having the contract enforced. What type of event makes performance impracticable? Impracticability, a severe shortage of raw materials or supplies due to war, embargo, local crop failure, unforeseen shutdown of major sources of supply, or the like, which either causes a market increase in cost or prevents performance altogether, may bring the case within the rules stated in this section. However, impracticability means more than practicality. A mere change in the degree of difficulty or expense due to such cases as increased wages, prices of raw material, or cost of construction, unless well beyond the normal range, does not amount to impracticability, since it is this sort of risk that a fixed price contract is intended to cover. Yeah. Must the occurrence be non-foreseeable? Or if the event is foreseeable, does that mean that the party seeking relief bore the risk? Restatement 261 says contrary indication. A commercial practice under which a party might be expected to insure or otherwise secure himself against a risk also militates against shifting it to the other party. So if the supervening event was not reasonably foreseeable when the contract was made, the party claiming discharge can hardly be expected to have provided against its occurrence. However, if it was reasonably foreseeable or even foreseen, the opposite conclusion does not necessarily follow. Factors such as practical difficulty of reaching agreement on the myriad of conceivable terms of a complex agreement may excuse a failure to deal with improbable contingencies. So that is impracticability. Frustration of purpose. Principal purpose is frustrated. The exchange called for by the contract had lost all value to the D because of supervening change in extrinsic circumstances. So this is the apartment rented to the king on a parade route, and the king fell ill and canceled. Restatement 265, discharge of supervening frustration, where after a contract is made, a party's principal purpose is substantially frustrated without his fault by the occurrence of an event, the non-occurrence of which was the basic assumption on which the contract was made. His remaining duties to render performance are discharged unless the language or circumstances indicate to the contrary. So this is like every Airbnb is number 4. Like they have language to the contrary. So you're not going to get out of it. Nuance. Why might a court decide that frustration of purpose was not applicable? And it says, how might a court know that I don't answer that question. So you got to look at the contract's words and say, like, is this applicable to this? Did the contracting party, was that their basic assumption? Did they know that that was the basic assumption in which the contract was being made? It was not the primary purpose. It looked to the text of the contract to determine the primary purpose of why the K was established. So this is where you can't say the primary purpose was to make money, because that's going to be like every contract. What was it? Impracticability and frustration of purpose both have elements. So substantial reduction in the value of the contract, performance is made impracticable, as opposed to performance was made, principal purpose is frustrated. So frustrated principal purpose, performance is impracticable. Because of this occurrence of an event, the non-occurrence of which the basic assumption of the contract for Apple's delivery did not account for alien invasion. Without the party's fault, the party seeking relief does not bear the risk of the occurrence of the event, either under the language of the contract or surrounding circumstances. So they're very similar, but one is this isn't the world we contracted for, and one is like the purpose, the principal purpose for doing this is gone. Impracticability hypos. On June 1st, A agrees to sell B and B to buy goods to be delivered in October at a designated port. The port is subsequently closed by quarantine regulations during the entire month of October. No commercially reasonable substitute performance is available. 2614 UCC. And A fails to deliver the goods. A's duty to deliver the goods is discharged, and A is not liable to B for breach of contract because no commercially reasonable substitute is available. The port is closed for quarantine, so neither one of them caused it, and nothing can be done. 2, a contract to produce a movie for B, as B knows A's only source of funds is a $100,000 deposit in C's bank. C bank fails, and A does not produce the movie. A's duty to produce the movie is not discharged, and A is liable to B for breach of contract. So those are impracticability. Frustration of purpose hypos. A and B make a contract under which B is to pay A $1,000 and is to have the use of A's window on January 10th to view a parade that has been scheduled for that day. Because of the illness of an important official, the parade is canceled. B refuses to use the window or pay the $1,000. B's duty to pay $1,000 is discharged, and B is not liable to A for the breach of contract, unless, of course, the contract says otherwise. A contracts to sell and B to buy a machine to be delivered to B in the United States. B, as A knows, intends to export the machine to a particular country for resale. Before delivery to B, a government regulation prohibits export of the machine to the country. B refuses to take or pay for the machine. If B can reasonably make other disposition of the machine, even though at some loss, his principal purpose of putting the machine to commercial use is not substantially frustrated. B's duty to take and pay for the machine is not discharged, and B is liable to A for breach of contract. We'll finish this. Contractual modifications, fair and equitable in light of circumstances, and this is Restatement 89. So there is a pre-existing duty rule, and we have a traditional and a restatement and a UCC. Great. So the traditional is when a party merely does what he has already obligated himself to do. He should not be compensated additionally. I like that one. Restatement 89 says modification of executory contract. A promise modifying a duty under a contract not fully performed on either side is binding. So if the modification is fair and equitable in view of circumstances not anticipated by the parties when the contract was made, to the extent provided by statute, or to the extent that justice requires enforcement in view of material change of position in reliance on the promise. Not surprising given the restatement's focus on bargain for exchanged. So if we can both change if the bargain is changed. The modification under the restatement. The UCC 2209, an agreement modifying a contract within this article needs no consideration to be binding. Comment 1, this section seeks to protect and make effective all necessary and desirable modifications of sales contracts without regard to the technicalities which are present that hamper such adjustments. So good faith. Modifications made thereunder must meet the test of good faith imposed by this act. So the observance of reasonable commercial standards of fair dealing in the trade, 2103, and may in some situations require an objectively demonstrable reason for seeking a modification. But such matters as a market shift which makes performance come to involve a loss may provide such reason even though there is no such unforeseen difficulty as would make out a legal excuse from performance. And then bad faith. The effective use of bad faith to escape performance on original contract terms is barred, and the extortion of a modification without legitimate commercial reason is ineffective as a violation of the duty of good faith. Nor can a mere technical consideration support a modification made in bad faith. And then we go to economic duress. A contract is voidable if a party's manifestation of assent is induced by improper threat by another party that leaves the victim no reasonable alternative. Wrongful, lawful, untortious are fine. So we've done this one. But that is, it needs to be a wrongful or improper threat. Circumstances permitted no other alternative. The threat actually induces the making of the contract. Such circumstances were the results of coercive acts of the other party. Some courts have held that a party agreeing to an assertedly coerced modification has a duty to make plain that it is acting under protest. This is in order to ensure that the other party will not be deceived as to its intention to eventually resist enforcement or seek duress. So you need to go through, make sure that, go through the elements of contract modification, good faith, and duress. And all that clear. We're going to learn more about that stuff.